All right, good morning, everyone. This is a special meeting of the members of the State Liquor Authority. Today is October 7th. Present today are here in New York City are Chairman Bradley, Commissioner Ford, Commissioner Fan, Deputy Commissioner of Licensing Roberts, Counsel to the Authority Meyerhoff, and myself, Secretary of the Authority Donahue. There is one item on today's calendar, which is 1967. It's a proposed advisory that was originally on the full board on August 20th. Just a few ground rules when we get started here. We're going to call people in the order they were signed in. First in Buffalo, if anybody's there, then in Albany, and then in New York City. The deadline for written submissions was a week ago Friday. We're not going to accept anything today in writing. Right? We're just going to hear from you or anybody who wants to be heard. Given the number of people, the chairman has set a limit of 3 minutes per person. That can be for your presentation, and then, of course, if the members have any questions, that won't be counted against your 3 minutes. All right. With that, Chairman, are you set to go?
Yes.
Commissioner Fan, Commissioner Ford? All righty then.
And we also have Adam Roberts, who's our Deputy Commissioner of Licensing, and Gary Meyerhoff, who is the counsel.
I got that.
Oh, I'm sorry. I'm not listening to you.
You never do that.
So, what the heck?
All right, we're going to
Close.
I don't see it. Michelle, is there anybody in Buffalo?
There's no one present in Buffalo.
All right, then we're going to move to Albany, and I'll start with the first names I have here so far. The first person I have is Kevin Duggan.
So before we get started, I do want to clarify a few things. One, there's been a suggestion that this, in many of the press reports, there's been a suggestion that this advisory came about directly focused on the delivery services, and I can't stress how incorrect that suggestion is. Many of the people in this room, as well as Albany, were part of a meeting that I led at the governor's direction, I believe in 2015, that dealt directly with this issue. The third-party services to our licensees and how those would be dealt with under the ABC law. So we've been talking about this for almost 4 years. This is not directed at any one company or any one portion of an industry. It's directed as guidance for our licensees about what we interpret the ABC law to hold. And the goal of this, because under the ABC law, the authority's interpretation has always been that no one who is unlicensed, is not part of the licensed establishment, is allowed to share in the revenues of the licensed establishment. There's been one exception made by the authority long before I was part of the authority, and that was for landlords. And that exception shows you that this authority has always believed that any portion of the revenues shared by someone who's not on the license is illegal under the ABC law. We are here, hopefully, to try to create another exception for these third-party providers, whether they be food delivery services, web providers. There's a whole proliferation of companies out there that are providing services to our licensed establishments, and the licensed establishments have asked for and we believe need guidance on the way that the fees for those third-party providers can be charged to the licensed establishment. That's why we're here. That's the genesis of how this happened, how this advisory came about, and hopefully we'll answer some of your questions or get some guidance on what you believe needs to be in place in this. This is a rough draft. It's going to change significantly, I would imagine, before we do vote on it. And that being said, I will leave it to Albany and Tom.
All right, Mr. Duggan, is it?
Yes, Dugan, but close enough, as it were. So good morning. My name is Kevin Dugan, and I'm the Director of Government Affairs for the New York State Restaurant Association. We're a trade group that represents food and beverage establishments throughout the state and have advocated on behalf of our members for more than 80 years. Our members are one of the largest and most widely impacted constituencies in the state of New York, as nearly every agency regulates some aspect of this industry. To ensure the continued viability of the restaurant industry, we work with all levels of government to prioritize regulations that enable these hardworking restaurant owners to continue to make their livelihoods in this wonderful industry. Today I'm testifying on the issue of third-party service providers and their relation to a restaurant's liquor license. I certainly do not need to tell the State Liquor Authority how vital these licenses are to a restaurant's viability. For many of our members, their ability to serve and sell alcohol is directly related to their ability to stay in business. We at the association understand the magnitude of any decision or interpretation that may alter the current operating system, and we are hoping to gain some clarity today on what, if anything, this draft guidance changes when it comes to who must be on these important licenses. To that end, the association has submitted a number of questions for your review. Those questions range from asking for clarification of the Liquor Authority's definition of profits versus gross profits, to important liability concerns the association has over who bears the brunt of punishment if this guidance is not interpreted correctly. As an association that represents the restaurant industry, we would have major concerns over any law that may lead to additional litigation against our members, especially if this were to come in an area that has no direct impact to the safety or well-being of our customers and staff. Any clarity when it comes to these concerns would be greatly appreciated. The draft guidance also makes mentions of profit sharing and the need to have those that enter into these types of agreements over the 10% threshold to be listed on a liquor license. In our opinion, many third parties do not enter into a profit sharing agreement as it is traditionally defined. Most service providers, especially those in the delivery space, take a percentage from particular sales, which again, we do not view as a profit sharing relationship. If the State Liquor Authority does view this as profit sharing and an issue that would fall under this guidance, we would raise concerns that while this may cap percentages at a 10%, we very well may see flat fees rise to a level that could potentially be untenable for restaurants to handle. We would appreciate some further clarity on this particular issue. We would also like to ask the authority if there has been any work done that scopes the impact of this guidance and its effect on the restaurant industry, specifically in what this may do to the third-party delivery space. While it is no secret the restaurant industry has some concerns with the fee structures of some of these companies, many restaurants around the state rely on these service providers to do business with a large segment of their customer base. Delivery is one of the fastest growing segments of the restaurant industry, and we would caution against any decision that could potentially close off this revenue stream to restaurants in the state of New York. Yes, work needs to be done when it comes to the relationship between restaurants and these delivery companies, but we would urge the SLA to carefully examine the impact of this guidance, as it may harm restaurants more than help them if this is handled incorrectly. As always, the New York State Restaurant Association stands ready to continue our partnership with the SLA to ensure the safe and responsible consumption at our restaurants. Again, very few things matter more to a restaurant's ability to remain open than having a valid liquor license. Adding more service providers to a license is something that restaurants do not want to do. We again thank you in advance for your review of the questions that we have submitted and welcome any further discussion on this important issue. Thank you.
So before we go to the next person, I'm going to beg, we have a number of written submissions. I have read them all. I believe these two have read them all. We will probably all read them again. We don't need to hear them. If you have something to add to them, add it. But we don't need to. They don't need to be read to us out loud. They are all part of the record here. So that being said, you guys have any questions?
How many members are in the New York State Restaurant Association?
We have probably about 1,200 members, and that represents roughly 3,000 to 3,500 brick and mortars.
And how many of them are outside of New York City?
I would have to double check, but a significant amount. I would say a little less than half, but probably like 40% of our members are outside New York City.
Okay.
Anything else?
No, and just for your clarification, we recognize that the advisory has multiple different terms in it, whether it be profit sharing or net profits, gross profits. That will all be fixed on the draft. How it's fixed depends on what we all decide, but it's all going to be consistent. So
fantastic.
I don't know that I can actually answer your direct question, but it will all be consistent when it all works out, should it pass.
Yep, that works for me.
All right, then the next speaker I have listed in Albany is Jennifer Sin.
Hi, my name is Jennifer Sin. I'm an attorney here in Albany with Bond, Chenick & King. I do a lot of liquor licensing work, and I'll just have a very, very brief comment. It may be something you cover as you discuss later on, but as an attorney that represents a lot of hospitality clients, particularly a lot of hotels, I'll just make one comment or one thing that I'm hoping may get clarified as the process goes on, and that just relates to the definition of an agreement that entitles a third party to a percentage. Several clients of mine have had a question or concern about whether or not an agreement where there's a fee based on something other than alcohol profits is going to fall into this definition. For hotels, sometimes we have clients that they have an agreement based on room rentals, that the fee will be based on their occupancy or percentage of frequency of events that may happen in the rooms that are unrelated to alcohol profits. Alcohol profits wouldn't be shared, and that was just a concern that we had, that we were hoping as the process goes forward might get clarified, if those would fall into this definition.
Well, so
That's
just to clarify for you, my understanding of the ABC law is that we're directed to regulate businesses, meaning not just the alcohol sales. And we do that with regularity, for example, with liquor stores. The law dictates what a liquor store can sell other than just liquor, and we enforce that law. So those are unrelated to alcohol sales. So just to clarify, you might want to go back and look at your McKinney's. I think that's already been decided, but I could be, correct me if I'm wrong, Tom.
Well, I mean, Section 110 does require applicants to list anyone who's interested in the business at the licensed premises, not the licensed activities at the licensed premises.
Okay. But that we'll try to clarify that as best we can.
Thank you. That was my only comment. Thank you.
Is there anyone else in Albany that wishes to speak?
No, sir.
All right, well, we're going to move you all from one room so that we're not.
Who these?
Yes,
we're
please.
just watching.
Oh, it's a watch party.
Game of Thrones is over now. They have to do something.
I have rarely been in a room that Mr. Webster didn't want to speak in. That's why I asked.
He almost, what? All right, then we'll move to New York, and the first person I have listed is William Tomaszewski.
Good morning. My name is William Tomaszewski.
Buffalo, if you want to end the call on your end, go ahead. And in Albany, end the call from the second conference room. I'm crossing my fingers. I'm not end the call. Okay. Mr.
You just want to
Tomaszewski.
put your name back on in case we lost the previous portion.
Good morning. I'm William Tomaszewski. I'm a general counsel from wine.com. Thank you for allowing me to speak today. Just going to make a few comments. I was involved with your task group a few years ago, Mr. Bradley, and I think we came up with a few recommendations. I don't know whatever happened to them. But I think when you redo and when you look at the comments, I think your main thing is try to be consistent. There's also another exception for credit cards. Credit cards take a percentage of every sale, and I guess that's not written into the law either, but that's happening on a daily basis for every sale that happens in the state. And I guess we just have to be aware of the fact that technology changes and business methods change, and I appreciate the Liquor Authority for trying to keep up with the changes in how economics and the economy works and how technology works. And that's about it. I was actually expecting to be the first one to speak today.
You get here early, that's the danger.
That's about it.
Okay, thank you. Thank you.
The next speaker we have is Robert Steen.
Good morning, Robert Skeen from the Skeen Law Firm. I put my submission in on the 27th, so I'm not going to reiterate that. But I do realize that this whole advisory was brought about because of the third-party providers, and I just wanted the authority to really understand how how some of the changes in policy could affect the traditional landlord-tenant and profit sharing that has been allowed by the authority, and take an opportunity, perhaps, to revisit some of these issues. I represent primarily concessionaires and operators of large premises, such as caterer at universities, airport concessions, and again, concert halls and sports arenas. And I would ask the authority to look at what other states have been doing, because they do practice in many jurisdictions, and we see that many of our clients are frustrated by New York with the 10%, 15% profit split.
So, and if I can just stop you there, because that's been reiterated in the reports as well as in your submission, which I saw, that this is a change in policy. I certainly didn't make the law. We're required to follow it. And the law is pretty strict as far as who can share in the profit or the revenues of a business with a liquor license. So the exception that was created was the landlord exception, and I believe that was back in the early 90s, or if not before that. So I'm not adverse if you're talking that the law needs to change, and maybe that's the case, and that's certainly not my decision to make. But this is not, all we're doing is interpreting what we believe the law says now.
Well, one of the issues that was caught some of my clients' attention was that we previously were able to bifurcate food and alcohol beverage at a stadium or a university, where the food sales could be pretty much any percentage, but the alcohol beverages must stay at 10%. And from my reading of the draft advisory, it appeared that the authority may want to do away with that, and I would implore you folks to take a hard look at that, how it would affect these concessionaires. I've been advised by authority personnel on several occasions about the food that in stadium context, that we can make the food higher, so as to bring the team more, the teams and the facility owners to get more of the revenue by limiting it to 10% of alcohol beverages or 15% with the authority's permission. So I'd implore you to take a look at that, because any change of that policy will have a dramatic effect on the concessionaires that are licensed by the authority.
Okay. We'll definitely take a look at it.
Thank you.
All right, the next speaker I have is Kevin Danow.
Good morning, Kevin Danow. I think that, Chairman, you've indicated this already, but my problem is basically that when I read this advisory, it doesn't advise me. It confuses me more than it helps me.
Yeah, the terminology, some of it's all over the place. I will give you that.
And I don't, wholly care what the law is. I just need to be able to know what it is and to be able to advise my clients as to what it is so that they can follow it. And this advisory doesn't do it for me, so that's one thing. I disagree respectfully with Tom. I don't really think that 110 of the law.
That's what it says.
It actually says, if the way I read it, it says any partner, joint venture, investor.
No. You're reading a different section of the set.
Okay. I think that we're dealing with availing here, and the issue is whether or not these people that.
Well, not just availing, but in certain instances, and that's certainly a big issue, but in certain instances, there's a list, which I'm sure you can go through off your memory, of people that are not allowed to own a retail liquor license. And I can name two off the top of my head, a manufacturer or a convicted felon that doesn't have relief from civil disability.
And my favorite, a police officer.
Correct. So that's also what we're talking about. If we don't have the ability to know if these people are on the license, we don't have the ability to enforce any law.
I am not at all suggesting that you shouldn't have the ability to know who's on the license or who a person who has a license is dealing with. The problem that I have with the advisory and where we're drifting here is that it's so ambiguous that any relationship that any vendor has, including an attorney with a retailer, could, and I use the word retailer for on and off premise, could come under this agreement, and then it starts to talk about whether or not the liquor authority is going to look at that. And I don't know whether that means that every time I file an application, I should send every agreement I have to the liquor authority. And I think you need to tailor this down so that we know what we're supposed to do, and then say something like all the rules about availing and people who are not allowed to profit from a license still apply. But to try to be this,
isn't that a given, though?
it is given, but what happens in this particular advisory, the way it's currently written, is it as you just heard. If I'm dealing with somebody who is giving advice to a retailer, it would come under this agreement. If I'm dealing with somebody,
But let me stop you there. If you're someone who's giving advice to a retailer, and under the law as it stands now, you're collecting a percentage of the revenues, you're availing the license.
perhaps,
No, you're under my view, you're availing the license.
if it's under 10%,
No, because
Okay,
this
so-
isn't. If it's 0.01%,
you're still availing the license.
that's my view. Yes,
Well,
the way the law is written.
I think that's an unusual view, but fine. I don't have a problem with it. If that's your view and that becomes the view of the agency.
Now you can charge whatever you want for your services under a flat fee. We're not talking about the level of your payment. We're talking about whether that's based on how much that restaurant or whatever it may be is making.
And I'm suggesting to you, sir, that the advisory, the way it confuses that, and what I would like to see is something that goes along the lines of, if you are charged, except you've changed what I thought you were saying, so it's good I'm here. But if you're charging a percentage and the percentage is under 10% of something, and you've already said that what that something is a little confusing, but you're going to straighten that out. But 10%, and I by the way, I think it should be gross sales. The reason I think it should be gross sales is it's the only thing that you can really get your hands on easily, and everybody else can. But and if it's gross sales, maybe it shouldn't be 10%. That's a different issue. But you want to ask for gross sales, gross profit shift item to item. It becomes a little bit difficult.
Well, and in my mind, being a former accountant, it's very difficult for an agency of this size to determine how accurate gross profit is.
And for that reason, I think if you say, it's this percentage of sales, you have something that you can look at, know what it is, and everybody knows what they're doing, which is the only thing I'm really interested in at the moment. But I was going to say to you, it applies, as you just heard, it applies to stadiums with concessions. It applies where somebody has a stadium with concessions, they have food in the past they've said, all right, we'll deal with the food, but stay away from the liquor, or we'll make sure that the liquor is under 10%. And you're dealing with all of those things, which is causing a lot of confusion into what has been traditional ways of trying to deal with the liquor authority. We just want to make sure that at the end of the day, I know what I'm doing and I know how to do it, so that I can advise my clients properly and that they don't run into trouble with you. And that's what an advisory is supposed to do. Otherwise, we don't need an advisor.
Mr. Danner, you're
3 minutes are up.
Well, I interrupted
I
him
added
twice, so go
quite a
ahead.
bit. So.
That's okay. I've said what I came to say.
All right.
Thank you very much.
All right, next person we have is Mr. Guerrero. You're not speaking?
I should have a little bulb that goes off.
I was going to throw my Arnold Palmer at you. Robert, is it Pulver?
No speaking today.
What's that?
I will not speak today. So did I put my name on the wrong list?
Patricia?
100% I thought it was a silent sheet. I'm sorry.
Oh, Patrick, I'm sorry. Next, Jacqueline Flues.
That name sounds familiar. Where do we know you from?
Hello, Commissioner Ford, Chairman, Commissioner Fab.
Ms. Flug?
Hi. This board has gone above and beyond other jurisdictions in putting out guidance to third-party providers through voluminous numbers of declaratory rulings. But what you have here is an advisory, not a declaratory ruling. And this advisory only focuses on one aspect of availing, the financial take of the third-party provider. And all the other declaratory rulings go to all aspects of availing. As you all know, there's more than one way to avail a license. We believe there are third-party providers who fail to disclose the retailer that's actually selling the product. We believe there are third-party providers that fail to disclose the retailer selling the product. Consumers have no idea who the licensed retailer is that sold them this product. Only the third party's provider's name is shown on the website or on the credit card statement or on the receipt. That, under your rulings, would be an availing. You have third-party providers.
Oh, but that would be an availing whether this advisory goes through or not.
Correct. But
So if those are reported to us, and I'm assuming you know who you're talking about, so I would expect that you would tell me who they are, having worked here previously, we would certainly enforce the law against them.
Well, I think the authority knows who they are, and I don't think that the authority has taken any enforcement actions. But my point is that there are also third-party providers who are picking and packing, which under your rulings aren't permissible, and there are third-party providers who are collecting the consumer payments, taking their quote-unquote cut, and then paying the retailer.
All right, we are back after a brief technical problem.
You're missing Commissioner Fan.
I'm just making sure we get everybody's here. Can you hear me in Albany?
Yeah, we're back.
Okay. forward. Mr. Coslow, are you going to be speaking?
Are you going to be speaking?
Yep. Sorry, yes.
Ms. Hoffman? You're not going to be speaking. Mr. Savitsky?
Yes.
You going to be speaking?
Yes, I will.
I'm afraid that Mr. Brookman?
I'll be speaking double.
Yeah, I have him.
Thanks for warning.
Mr. Saunders?
No, I'm Marty. Mr. Mayor will be speaking instead.
Mr. Bernstein?
Yes.
Anybody I call who plans on speaking that didn't sign in yet? All right.
Is this your first time?
Just in Albany, you're not missing anything. We're just waiting for Commissioner Fan to return. Okay, go resume with the special meeting.
So, Chairman, my point was that there are other aspects of availing that aren't addressed in this document, which is an advisory, not a declaratory ruling. Once this document is final and it's an advisory, industry members will be looking to this. Again, this is New York, the largest market for alcoholic beverages. Other regulators have even cited to the prior New York declaratory rulings. If these other aspects of availing aren't mentioned here, it's doubtful that people will go searching through the declaratory rulings for the nuances, for the granular details, and will just rely on this advisory because it's the only one on third-party providers. So we're asking that this advisory simply be comprehensive. You do have a large volume of declaratory rulings which could be consolidated in this. This advisory also really fails to distinguish between on-premise and off-premise, which has been a theme throughout the declaratory rulings. And the discussions that this board have had has always seen on-premise and off-premise differently because the thought was that a on-premise entity might be dealing with several third-party providers, and that the thought that one of these third-party providers was going to really come in and start making the essential business decisions of a restaurant was unlikely, as opposed to the scenarios where the authority has seen third-party providers that come in and literally have taken over liquor stores. So the ask here today, and why I'm standing here, is just that if the board is now taking the position, and it's 3 years after the ABC Task Force on E-commerce, that it be a comprehensive document that everybody can turn to and have all positions of the authority in one place.
Okay, thank you.
Next, I have.
And you can thank Jackie Flug for the fact that we're all down here today because she didn't want to take the train up to Albany.
Thank you, Jackie. Thank you, Jackie. It's the first time I ever said that to you. Thank you, Jackie.
Next person I have is Zachary. Is it Hecht? H-E-C-H-T?
Read my handwriting. So I'm Zachary Hecht. I'm the policy director of an organization called Tech NYC, and we're a nonprofit association with the mission of supporting the tech industry in New York through increased engagement between our members, which are about 750 companies, New York government, and the community at large.
How many licensees?
No, that I'm aware of. So they're
Any?
technology companies.
Oh, none that you're aware of.
Yeah,
Okay.
none that I'm aware of, but we have several members. So. But we work every day to foster a dynamic, diverse, and creative tech ecosystem here in New York and ensure that New York is the best place to start and grow a tech company and that New Yorkers benefit from the resulting innovation. I submitted most of what I was about to say in writing, so heeding your recommendation, I'm not going to just regurgitate it to you, but I want to reiterate that the regulatory uncertainty that is contained in the advisory would be very concerning for tech companies. Innovation.
What's uncertain about, other than the language we talked about?
The language and whether or not.
But I mean, the general gist is you can't charge over 10% of revenue. So what's uncertain about that?
So it's the monetary value of sales versus profit, gross profit, and what we're talking about there.
That will be clear.
So, but the regulatory uncertainty is really concerning. And then I think the idea here is to make sure that no one is. I mean, there are other reasons, but that no one is hurting some of the restaurants and the industry, and they're taking too much money. But there is a lot of competition in this space. We have several different companies that are working in this space. And we think that restaurants are able to choose from a suite of options that would benefit them.
So, I mean, to be clear, we're not trying to protect any restaurant or liquor stores or whatever the case may be. We're trying to clarify what we believe the law is now and perhaps create a safe harbor. What the market dictates should be charged for whatever services your companies are providing, the market will dictate. I mean, that's basically my view on it. Now, whether you charge it in a flat fee or charge it in a percentage, that if this advisory passes means you can't go above 10%. That's all. The flat fee is the flat fee. The market dictates how much that is. So I don't anticipate the competition should change.
You know, I think it would be that it could impede innovation in the back end, and it's
how.
So some of the.
I mean, based on what I've witnessed of these tech companies, should anyone go out of business because of this, which is not our goal at all, I would imagine there's 20 other people willing to step right in and follow the law as we dictated it. So, you know, I understand that perhaps people's business operations may have to change a little bit, but at the end of the day, if they fail because of this, then they were probably going to fail anyway.
You know, it's not failing because of that. It's the regulatory uncertainty. And it's that when you're creating a new technology or innovating a service, you need to be really clear with what we're working on. And there will be new things that come about.
Right.
Without a doubt. So
that's the nature of technology.
So, exactly. So it's when we're regulating the space, we need to be very clear with what our intentions are.
And the reason this happened, in my view, is because it wasn't either somebody didn't go and read the law and follow up before they started doing business with licensees, or it wasn't clear beforehand. That's the attempt we're trying to make, is to clarify it. You know, because there is, as I said, a proliferation of companies out there, most on the tech side, but not all, that are charging percentages well beyond what they should be. And we're aware of that.
So is the beyond what they should be based on?
They shouldn't be
the
charging
law,
anything.
Or it's based on?
It's based on the law. Under our view of the law, they shouldn't be charging anything, percentage-wise. They can charge flat fee, whatever they want, whatever the market will bear. But they shouldn't be taking a percentage of profits, revenues, whatever the case may be. We'll make it clear in the advisory what we say the advisory says. But I mean, hopefully this will not create uncertainty. It should create certainty when somebody's coming into this market.
Yeah, and we welcome the further advisory. And, to reiterate what some of the other folks have said, it's the downstream effects and how it applies to non-technology companies as well has to be considered, and the relationship.
Well, see, this is not, we didn't do this with that industry in mind. We did it because we have licensees that we're required to regulate. And they need some guidance because there's a lot of them out there hiring these companies and entering into agreements that, in our view, aren't really in line with the law. Doesn't mean they can't take the service. They're just not, the agreements themselves as they're structured are not in line with the law. Hopefully that will clarify. This will clarify that.
Okay. Thank you very much.
All right, the next speaker I have is Mark Kozlow.
Morning, Mr. Chairman. Mark Kozlow from Buckman Law Firm. I'm not going to add to the comments. I gave written comments to the members. I respect that, Mr. Chairman. Just 3 points. One is, it seems that the thrust of the advisory is on the retail license holder. It doesn't quite say that in the advisory. It alludes to it, implies it, doesn't quite say it. You might want to take a look at the language and make sure if that's what the guide's supposed to do, that it's for that purpose. The second thing is, when you're considering remarks were brought up about the separation of food or other services from the alcoholic beverage services, I concur with what the Secretary said. There's another section of law that the reason why you get an alcoholic beverage license as an on-premise licensee is for the service of food and beverage. The statute doesn't let you separate the two. So I suggest that when you take a look at this and you're trying to carve out the exceptions you're trying to carve out, just keep in mind the statute says something, and I would take care as to how you want to carve it out of the statute. Okay? It's there. You can't ignore it. And the last thing is, there's a comment made in the advisory.
I'm not following you. So you think we are trying to carve that out in what you've seen?
You're setting up, the remarks here today were about, we're trying to keep things separate. Yet there were the different carve-outs. Food is this, but I can get a percentage of food. I'm keeping it away from the alcoholic beverage segment.
That's not our intent at all, I don't believe. Is that the way you read that? That was Mr. Skeen's comment.
Right. These are comments of people coming up.
Yeah. Oh, yes.
And that I would say that, although I'm certainly not opposed to that, I'm in favor of having graduated things that have to be done to make the industry work appropriately. Keep in mind, there's a statute, aside from the statute that the Secretary mentioned, the basic statute of getting an on-premise license is for food and beverage. You can't just ignore it.
What section is that? Do you know off the top?
104. I think it's 104. Food and beverage. OP license.
No,
the other 64.
64. I mean, they all require
in other words,
a food component.
The way the Liquor Authority set up its structure for alcoholic beverage licensing for these types of accounts was they created a restaurant, back in the old days, a restaurant license, and there was a tavern license.
Right.
Tavern license didn't need to have the food, or very basic terms. Kind of phased out, became an on-premise license, but the statute says those two things. I'm not opposed to it. It should be done, but care has to be taken.
Okay.
And the last thing is, sorry. The last thing is there were comments made about I wouldn't say disregarding, but again cautioning those who have been relying on declaratory rulings in the past. And I would say that just the reverse. The reason why the Liquor Authority publishes these and why they're made available, whether it's under Freedom of Information law or whether it's because the authority does it on its own, is to enable counsel or others to look at them, review them, and if their fact pattern meets the same fact pattern, rely on them and go forward. It would be very damaging to the industry as a whole if you just said, nope, can't rely on them. Nobody's grandfathered in. And although I wrote that, I thought I'd make the point, and I emphasize it today because I think it's very important that those precedents do be maintained. In the bad old days, nothing was published. You had to rely on counsel, whatever knowledge they were able to discern or ferret out on their own to figure out what the authority felt or meant. Now, at least it's published. They have to say at the same time, no, I know the declaratory rulings do say if They fit for those people, for those entities. No one's supposed to rely on them. But the authority itself, when you publish data on your own, when you have other advisories, not the declaratory rulings, you refer to the declaratory rulings. You're relying on them yourself. And at the same time, to say, no, don't rely on them, don't be grandfathered by them, even if you're not a party to them.
I get the argument, and I don't know where we stand on this, and we'll certainly talk about it, that if a company came in and got a declaratory ruling,
Well, they're safe.
well, I don't know if they are or they aren't, but that remains to be seen. But now you're arguing that someone else that relied on another company's declaratory ruling should be safe as well?
Yeah, well,
That's not going to happen.
well,
That's why we say facts. I don't care whether it's published or not. I mean, you're not. Is that company going to be able to fit into those specific set of facts that was written for another company?
Usually they do. In other words, when you see a declaratory ruling, you're giving guidance to your clients. You're saying, here's the fact pattern. If you meet this fact pattern, you can rely on the fact pattern.
That's not what the declaratory ruling says, though. That perhaps should mean you should get a declaratory ruling.
What, and flood the liquor authority with the same declaratory you just issued?
Well,
The authorities never wanted that. You never wanted to be flooded.
but we never expected somebody to rely on them and expect to be grandfathered into an advisory.
Well, you refer to declaratory rulings in your advisories. You refer to them when we have discussions with counsel. This is not something unknown. It happens every day. Suddenly say, no, don't do it. That's fine with me. If you want counsel to flood the liquor authority with the same fact patterns you've approved to get declaratory rulings, which, by the way, once they're issued, to look at the rule, you can't reverse them.
Provided that they set the facts.
No, you can't retroactively reverse them.
Correct.
You can change them going forward.
That's forward. But they're safe.
Okay.
They're safe. What I'm saying is that...
No, I get what you're saying. We'll talk about it.
Thank you very much.
Next speaker I have is Benjamin Savitsky.
Good morning, members of the authority. Ben Savitsky. First, just want to thank you for the opportunity to comment on the proposed advisory. Our office submitted a letter on September 26 requesting clarification on whether a licensee may act as a third-party provider and enter into the types of arrangements that are contemplated in the draft advisory. The draft advisory, and we understand that the authority right now is trying to memorialize the guidelines that govern the unlicensed entities, but what we're curious about and what we've had clients ask us, specifically clients who have active licensees, is whether or not they're able to participate as active licensees in the same services that are being provided by unlicensed entities. I think in my letter, and I'm not going to go into it because I know you guys don't want us to, I gave two examples of two licensees who have contacted us. One is an on-premise retailer or a restaurant that wants to post its products online and link to an off-premises liquor store and say, hey, you can get these products here if you really like them at our store, and then take a percentage of the sale. And that would be a
somebody correct me if I'm wrong. I don't think they can do that now.
Right. Well, that's what I'm asking. Is
under the law?
That's what I'm asking.
No, I don't. With this advisor or without it, I think it's illegal.
Well, that's what I'm asking. So a third-party provider that would be able to provide the ability to go to an off-premises liquor store.
You don't want to give us the name of this?
No, they're not.
They're not doing it yet. They're not doing it. But what they're saying, what they read the third-party provider advisory to say is that an unlicensed entity will be able to direct to an off-premises liquor store and pick up products for customers and bring them to those customers. So all they're saying is, in the same way that they act as a marketing entity or a delivery entity, would a licensee be able to similarly provide a marketing to an off-premises liquor store and say the products that we offer in store, you can also get them.
So you want a liquor store to pay a percentage to a licensed on-premise location that is referring customers to you?
Like a referral fee. I think in your letter you said something like
something similar to that. And
that can't happen, correct?
Well, the thought behind it would be
whether percentage or not. I don't think it's legal.
I think
if you use a third party.
I think the question is, and correct me if I'm wrong, that if you're going to say an unlicensed third-party provider can do A, B, and C, can an entity that also happen to have a license and is providing those same third-party services, doing A, B, and C, also do whatever it is that you're going to sign off on? Is that your question?
That is the question, yes.
Yes, as long as it doesn't violate some other area of the ABC law,
Absolutely.
Which the example you gave
like the Tide House.
Well, obviously, it wouldn't violate Tide House. If we're talking about a retailer to a
retailer.
No,
right, but he said similar to
Absolutely,
a Tide
yeah.
House, right.
But if you're talking about a retailer to a retailer, and there is the ability of an on-premises retailer to have an interest in an off-premises retail establishment, just one. So it would be a similar situation where if I'm an on-premises retailer, I operate a restaurant, I have this great wine list there's a local liquor store in the neighborhood and they also have these wines, and I could tell my clients, my patrons, hey, you can go pick up these wines at this store if they have them and provide a link on the website. That would be something that an unlicensed TPP would be able to do. And what we're just asking for clarification on is, if you are allowing an unlicensed entity to do those things, can a licensee do those things as well?
As long as it's currently legal under the law, yes. Okay. We're not changing any other part. We're not interpreting any other part of the law.
So what we're saying in this draft.
But I have to say that relationship makes me uncomfortable. As your example, I don't know off the top of my head if it's legal or not. I have other people here to tell me that. Right. But I am uncomfortable with it.
Right. Oh, and then the other example would be a grocery beer licensee who would be able to link to an off-premises liquor store and say to customers, hey, if you want to buy from us, you can also buy from this other store, and we can combine services for delivery. That would cut out the unlicensed TPP, and you'd have two licensees who are kind of acting in concert for a single product, and there would be some sort of percentage sharing, less than 10% or less than whatever your draft advisory is saying. But again, this is something that
doesn't sound legal to me.
It doesn't sound legal to you, right? But
we're not changing. We're not. All this is changing how, not changing, but interpreting how you can be paid, not how much you can be paid, not who can be paid. Right. It's interpreting how you can be paid.
But under the draft advisory, what you're saying is that an unlicensed TPP, someone who's never gotten a license before, can act as a third-party provider to two separate licensees and collect revenue from two separate licensees, and that's okay. But you're saying that one licensee who holds a grocery beer license.
We're not saying anything about that.
Well,
that's what I'm saying.
So that's what I'm asking for clarification.
We're not clarifying that at all. If that's legal now, then you're going to be able to do it after this advisory. If it's not, you won't.
Okay.
And I don't know off the top of my head if it is, but we're not changing that.
Okay.
Next person I have, Robert Bookman. I'm starting your clock now. It's counting your walking time up here.
I'm speaking on behalf of hundreds of people. I just wanted to introduce Andrew Ritchie. He's the executive director of the New York City Hospitality Alliance, the organization I'm here representing today. Represents over 2,000 small business establishments in the city of New York. And we submitted written testimony. I'm not going to go over any of that, but I did read everything else, and I have a number of comments concerning what was submitted. And I just want to make it clear from the outset that
before you get into, I want to hear what your association stance is before you comment on what everybody else says.
Just make it clear, our association strongly supports your efforts in this area. We are in a world now where we have partners who are demanding a greater and greater percentage of our revenues, yet these are partners who are operating outside the scope of the law and regulation, and that has to stop. That's our position. Our firm position, quite frankly, is that by allowing any percentage to third-party providers, you are opening up a Pandora's box of questions and issues, some of which you've already heard, some of which have been in written submissions. Once you allow individuals who might be ineligible to be on a liquor license for statutory disqualifications, to say, okay, I can't be on the liquor license, but I can create a consulting company and consult on human resources and take 10% of the revenue. And I can create a second consulting company. I can consult on food and take 10% of the revenue. So we now have individuals or companies that may have substantial investments in manufacturers, that may be convicted felons, that may have had licenses revoked before, and you're opening the door for allowing these individuals to effectively be partners in liquor licensees without you knowing anything about them. Now, I don't know when the landlord exception came about. I spoke to my partner who had been counsel here in late 80s, early 80s, early 70s. He said it was here then. But
do you know?
Marty May was probably the only one old enough to know.
Yeah, when I came on board with the Liquor Authority in 1974, it was in effect, and it had been in effect for many, many years, especially as to landlords.
But even with landlords, you know a lot more about landlords than you know about these third-party companies. You have their leases, their contracts. You have a landlord ID form. You don't know anything about these companies. And again, we're not talking about just billion-dollar publicly traded corporations. You're talking about anybody who could set themselves up and call themselves a third-party consultant. So our position is what the law has always been, the way I've been trained, the way people here at these days trained me, and how every council before that trained me in the years I've been here, every chairman and every commissioner trained me, is you get a percentage of revenue, you're called a partner, you're on the license. It doesn't matter whether you're a managing member or a shareholder that has no voting rights whatsoever. You own a percentage, you're on the license. I don't know why we should deviate from that at all, quite frankly, because it does open this Pandora's box. But if you do, if you choose to, I think the situation is rather clear, as you stated. It's not complicated. The law says what it says, and we come here today armed with the law. If you share in revenues, there must be full disclosure of anyone with a financial interest in a licensed premise. The law requires that an applicant or licensee have full control over food and beverage sales at licensed premises, and this law must apply to everyone, no exceptions. The opponents of the advisory seem confused to me. They keep repeating in their written submissions incorrectly that the SLA has no authority over anything at licensed business other than alcohol sales. As you said before, Mr. Chairman, that's clearly not the case. The whole regulatory structure is based on you regulating the business that sells alcohol. Everything from the requirement of food at licensed premises to the amount of food for a restaurant, compliance with local laws, signage, bathrooms, none of which has anything to do with alcohol sales. But of course you regulate all of that. And to rule otherwise would destroy the entire regulatory system. You could have a person that would then come to you and say, I'm a 50% partner in just the food in the restaurant. I'm a 0% partner in the alcohol. And therefore, if you agree that you only regulate alcohol sales, you're going to have situations where you have people who really own parts of restaurants who aren't on the liquor license because they're only alcohol partners. Obviously, that's crazy. And I'll finish up. All your third-party rulings, which I've reviewed and have been clear, that they could charge a flat rate or a small percentage of revenue as long as it does not exceed 10%. Beyond that, you've stated their interest is not de minimis. When a platform that does nothing more than transmit an order receives 25% or more of the total revenue, we're way beyond de minimis, and way beyond them not having an influence in what goes on at that business. And as far as it's true for internet marketing companies as well as lawyers, the solution to all this angst is simple. Charge a reasonable flat rate or a percentage, no greater than 10% if that's what you're doing. I've represented thousands of people over the years. I didn't know I could even bill them a percentage of their revenue. I charge them a flat rate. So I don't think that accountants or lawyers or purveyors or anybody charges a percentage. They charge a flat rate. And we hope that, and including that the SLA and this governor, you've been really supportive of a vibrant industry. You've been doing a lot over the years, which helps us. Businesses are struggling. We feel like we're David versus Goliath here, and that we hope that you support David.
All right.
Thank you.
Thank you.
Martin Mailer.
Andrew had signed up too. Right next to my line.
So, good morning, Andrew Ridgey. I'm the Executive Director of the New York City Hospitality Alliance, the organization Mr. Bookman just spoke on behalf. Just want to make something really clear. First, I'll say again, thank you for hearing this. If the authority is concerned about third-party entities and their influence on liquor license establishment, I just want to note that over the years, the percentages that certain companies have taken have started, under 10%, now sometimes exceed 30%. And when a licensed establishment is paying up to 30% or even more of their sales to a third-party entity, that third party has incredible influence over the operations of that licensed entity. It determines the types of food they are purchasing. It determines what they are going to put on their menus because of food costs. It's going to determine whether or not they employ delivery people to deliver the food or whether they should employ them directly or hire them through third parties. So the point is that as companies continue to call restaurants their restaurant partners, if they are their partners, which if they're taking such an influence or have such an influence over the company, we believe they are, in a sense, a partner, then they should be disclosed. if they are not having that type of influence and they are levying just a flat fee or a fee, in this case under your proposed advisory, less than 10%, they would have less influence. But as the percentages continue to increase and increase, there is a significant impact on a licensed entity's operations. And I think that's very important for you all to think about and consider during your consideration and deliberation. So I want to thank you again, and of course we're happy to answer any follow-up questions.
Okay, thank you.
Thank you.
Mr. Baylor.
Oh, he has, hold on, Commissioner Fan has a question.
Back, you mentioned the 30% that are, in theory is being charged, and that's on the sort of the high end. That's 30% of each delivery, right?
Correct. Usually, if you're talking about just the deliveries, it's based on the sale. So if the sale is, $50, it would be, 20 or up to 30% of that sale.
Okay. And so do you have generally, this is like a big question, but like as far as your members go, do you have a sense of what percentage of their total revenue is actually coming from deliveries?
Well, so it's changing. I think we're really at a transformative time in the industry right now. We have members, 20, it could be 15, 25, some places even 30%. And what's happening is as the segment and trends are changing where more people are ordering in, they're ordering to their office, this percentage continues to grow. And I just saw a commercial this morning from a delivery company. I got on the train. I saw an ad for a delivery company. So there are millions of dollars, actually, millions upon millions of dollars that are entering the marketplace to influence more and more people to eat at home. And many of the transactions that are, transacting deliveries are through third parties. It's not just restaurants directly. So it's a growing percentage. Like I said, it can range 15 to 30%, but restaurants, because of just dining habits, that's continuing to increase. So the third parties, in effect, continue to take a larger and larger percent of revenue from the licensed business, which in turn gives them greater and greater influence over their operations.
Right, but up to 30%, 30% of 30% is 9%. So that's still under 10.
Yeah, so 30%. Yeah, well, I guess one of the things, again, the clarity on what it is saying. If it's then that would be 9%. Sometimes it increases. The fees. There's also additional fees usually built into the percentage. So
no, I understand. But from the viewpoint of your member restaurants, you're not arguing that the take is actually more than 10% of overall revenue because 30 of 30 is 9%.
Oh, I can't talk. I can't talk on behalf of all of the restaurants. What I can tell you is that they have questions currently, about what the law is, and they want clarity there. So, in the case, if that's the interpretation, that it would be less than 10% of the sale versus less than 10% of the business's gross sales, it would be under 9%. It would be 9%, which would be under the 10% cap.
Okay. All right. Thank you.
Come on up.
Thank you.
Good morning, Commissioners. My name is Martin Mailer from Mailer Buscemi. I'm here on behalf of the Retailers Alliance, and I have to open up by saying I apologize for not having any written submission, but I was only called upon last Thursday to express the opinion of the Retailers Alliance. So your rules.
Busy this weekend, or?
You have no idea how busy I was over the weekend. I just moved. But that aside, initially, I'd like to say that I agree with the chairman in the sense that if you look at Section 111,
that's first.
Well, it's not a first, but
yes, it is.
If you look at Section 111, Section 111 is pretty clear in the sense it doesn't create any percentages. And if you wanted an analogous statute, you can take that a wholesaler or / manufacturer cannot have any interest in a retailer. And you can look at matter of Riga, where some beer company in Japan had whatever that percentage was. So if you take a literal reading of that statute, I would agree there should be no percentage. But maybe within the wiggle room of Section 111, you can create some sort of percentage. My goal here today is to speak for retail off-premises licensees, a.k.a. liquor stores. With respect to what everybody's saying, in my opinion, with an on-premises situation, it's much ado about nothing in the sense that all we're talking about is beer. You can't transport wine, you can't transport liquor off premises.
That's
So-
just when you're talking about the delivery.
Right.
What about the, back to Mr. Gano's point, what about the lawyer if he's charging 30%? What about the guy who administers your web page? What if they're charging 30%?
I agree with Mr. Dan in the sense that there should be clarity as to what we're talking about, whatever we're talking about. In a sense, I mean, if you want to get technical, I don't charge a percentage, but if I was to charge a percentage, it would be for an application where the person isn't a licensee. But I don't want to get off on a tangent. What I want to talk about is the difference between an on and off premises licensee. And in answer to your question about a possible violation, if the restaurant would allow the liquor store and then collect a percentage, I think that violates 64 because it skirts around the issue of whether you can transport spirits and wine off premises. But I don't want to get into that to any great degree. The thing that I want to talk about is the percentage. Because when you talk about on-premises licensees, we're not limiting ourselves to what the markup is. In other words, a restaurant can charge what it wants to charge based on its reputation or whatever else that may be, and for all I know, they may be making 300% on whatever their costs are. But with respect to off-premises licensees, it's very limited. All we're selling is spirits and wine. And when you say 10% of gross revenues, in essence, you're taking about 30%. The average liquor store, let's say, makes 30% markup on whatever it is that it's selling. So if you take 10% of its gross sale, you're talking about the third-party provider getting somewhere between 30 to 50 to 70% because their markup can't be that high as dictated by all the other stores in the area. So if you're going to allow for some sort of percentage, for a third-party delivery system, I think you have to divorce on-premises licensees from off-premises licensees. And I would suggest no more than a 2 or 3% markup or percentage when it comes to off-premises licensees. Otherwise, the off-premises licensees, which are dealing with very low percentages to begin with, are really going to be hurting.
Mr. Mailer, you're up against your time, just so you know.
No, okay, so
I have questions for him. So, and I get you're not the first person, obviously, to raise that there should be a divorce between the two types of establishments. But whether there's a percentage or not, isn't the market going to dictate, and shouldn't the market dictate what the off-premise licensee is paying for delivery? I mean, at the end of the day, they can do the same thing without charging 10%.
Yeah, who's they?
The third-party provider.
Yeah, so
they can say our flat fee for this period of time is, and do the 50% math in their head.
Ideally, I'd rather see a flat fee, so at least you know going in what you got. Yes,
all right.
But
okay.
but if you have to, if you are going the route of some sort of percentage, I would suggest that there be no more than a 2 or 3% markup for off-premises licensees because of the low margins they have to begin with, and they're not selling food, they're not selling anything, but once some corkscrew scale comes through, they're not really selling anything other than.
But they're under the same lease exception as the retailers, correct? 10% for the landlords.
Yeah, yes, but like I said, I go back to at least 1974. I don't know one situation in all those years where a landlord charged an off-premises licensee. I can tell you hotels, I can tell you restaurants, but
I know it upstate.
Well,
I don't know about New York, but I know upstate it happens.
All right, well,
a bump. Here's a flat fee, and then over a certain amount, you get a bump, and we're taking 10% or 10%.
Yeah, but in actuality, that becomes like a 2 or 3% markup because
right.
you got to hit a certain bump,
right.
or $1 million, whatever the number is, so that it's not a true 10%. So I'm saying, based on the difference between an on-premises and off-premises licensee, please, if you're going to do this at all, and I suggest you may not have to do it if you're really going to take a strict interpretation of 111, that you limit off-premises licensees to a much lower percentage.
Right. You keep saying 2 to 3% of markup, but what you mean is
it
should be 2 to
gross
3% of gross sales.
Right. If that's right. Yeah, I understand what you're saying about gross profit being very difficult to ascertain.
Well, we couldn't regulate.
No, I would agree with that, but I'm saying no. I'm sorry. I meant 2 or 3% of gross sales.
I understand.
That's what you mean. Thank you.
Donald Bernstein.
Donald Bernstein, good morning, Mr. Chairman, Commissioners. I think, Mr. Chairman, you started this meeting by saying that historically there was one exception to the general rule of not sharing revenue, and that was the landlord-tenant relationship with the percentage rent. But there are two others. One is the 9 years of declaratory rulings that the authority has issued on third-party providers. And though the fact patterns in those may have been a little different for each one, there is a sort of general theme that if you're talking about 10% or less of gross sales and all control is with the licensee, they seem to have been approved. And that's 9 years of rulings. I have to agree with Mr. Kaslow about that, but I think the industry has relied on that to some extent in creating some business transactions, and I would hate to see all of that disappear in a rule.
And I understand your point, and I understood his point, but at some point, when the declaratory ruling itself states that this only applies to these specific facts, whose fault is it that they're relying on something unless they, word for word, fit into those specific facts? And even then, I would argue that...
I agree with that, but I think just as a general course of where the authority's been going, I think there's a sense that if we're talking about 10% of gross revenue or less and control with the licensee, we're at least in the ballpark. So I would hate to see anything revolutionary to change that. There's another area where there has been an exception. Now, I pointed out in that letter, but I do want to highlight that, and that is food concessionaires. There are a couple of rulings that have been issued. I think the last one was 2015. You can have a food concessionaire. We have this with our catering licenses, where someone who is not licensed is providing food to the establishment. They fill out the one-page catering food concessionaire petition. They are not on the license. And there is no limit as to how much they can share in the food revenue. There are instances where they may be getting 100% of the food revenue. I think Mr. Skeen may have been alluding to this in ballparks and other venues. So I think there is a historical track record of the authority not regulating revenue from food. And I understand that the authority can regulate food because the statute requires that there be food. But the statute does not say that someone who shares in just food revenue must be on the license. I don't see that in the statute, and that is borne out by the fact that food concessionaires do not have to be on the license, and there's no restriction in the amount. So if you have a food delivery service that is charging more than whatever percentage you finally decide on, I think that's akin to what has been longstanding with respect to food concessionaires. Last point I want to make, which I think has been hit on, I can't stress enough how unworkable I think sharing of profits, whether it's gross profits or net profits, whatever those mean. Historically, it has been 10% of gross revenue, and I urge you and hope that whatever the end result is, it be based on gross revenue, not profits.
Okay, thanks.
And so last call, no pun intended. Anyone in Albany want to speak?
Or speak again. I didn't realize there would be this few people. So if someone wants to speak again,
I just one quick
well, no. Let me.
I just want to raise my hand.
I didn't ask you to raise your hand yet. Anybody in Albany want to speak, or anybody who has already spoken want to speak again? Anybody other than Mr. Bookman? Anybody who hasn't spoken? Mr. McCown?
How can I?
Wait, hold on. What's that?
He said no in Albany.
The question is, how can I access the written submissions?
FOIL.
You can submit an email to the board info email address and get it from there. Anybody else besides you two? Okay. Mr. Dano, you spoke first, so why don't you come on up?
Means I get the last word, right?
Oh, you get the last one.
That's it.
I didn't say you were coming up.
Which is hard with you.
I just wanted to point out that when you're thinking about this, you have what Commissioner Fan was talking about, that 10% of gross revenues is not the same as 10% of each sale. So you have to consider that. You have the Groupon advisory, which said that it was okay to have 50% actually of the Groupon, provided that it didn't come to more than 10% of the overall sales, and they didn't do it more than a certain number. It's just something to think about. And the other thing I'd like you to think about, if you don't mind, is that sometimes what happens with these things is they say the number of sales, not the amount of the sales, but I want a flat fee per sale. So I think that you should address that as well in terms of all of this, so that at the end of the day.
Well, what? So I'm not following why that would be illegal.
I'm not saying it would be illegal. I'm not suggesting. I'm only suggesting again. I'm here so that at the end of the day, you put out the advisory, and I know. You know, I have to say,
I get what you're about to say, but but explain to me the flat fee per sale versus flat fee over a course of 12 months.
Because what you're going to potentially see is somebody gives a flat fee, and the flat fee is per sale, but it might come to more than 10% of the gross. If that's going to make a difference to you, I want to know about it. I'm not suggesting what your answer should be.
Right.
And the other thing that I think you're going to see is that people offer various services. So you're going to perhaps see these companies saying, "Okay, I'm going to charge 8% of the profit or of the sale on a particular sale, but I'm also going to offer you computer services or some other services." And how do these interrelate into what you're saying? If I'm offering 2 or 3 or 4 different kinds of services, you know, and part of it
why would that change the analysis?
If part of it is at a percentage and part of it is a flat fee, then the flat fee pushes the percentage, so it changes the analysis. How it changes the analysis is really up to you. I'm not suggesting. You know, what I would say as a last statement is that when a client comes to an attorney and says that they want to do something, and there are declaratory rulings on that subject, what you're going to find is that the attorney will say, you can go for a declaratory ruling, or you can look at these declaratory rulings that express the opinion of the liquor authority, and you can rely on them with some, you know, if you go for a declaratory ruling, you're safe, but you have a right to rely on them in terms of trying to understand the liquor authority's thinking. And when you make a drastic change from that, you have had many people who have invested lots and lots of money based on.
But that, once again, goes back to what I'm saying, is I understand you should read them to see which direction we're going in. You should read them to see where we've gone before. But at the end of the day, particularly if you're investing lots and lots of money, I know we have been very receptive to receiving them since I've been here. I know the chairman before me was even more so. And
absolutely, but
why wouldn't you just do one? I mean, at that point, I don't have a lot of compassion for those people that decided not to come to us.
Well, perhaps you should, because I give you a very.
I probably should in every aspect of my life. But
before you give the example, is there any case law on this? Has it ever been tested?
Not that I know of. Mark Haswell might know better, but not that I know of.
Whether a licensee has the right to rely on declaratory rulings.
Mark?
It says in the rule you can't. You know, it says in the regulation itself that the SLA cannot retroactively change a declaratory ruling, but only to the participants of that declaratory ruling. That's all you have. No one's ever tried to go to court and say I relied on it.
I'm sure lawyers that advise clients about whether or not they can rely on such declaratory rulings are clear to say that that's not 100% reliance, because the ruling itself says you cannot rely on it. You're at some level of risk.
I'm not saying, Marty,
I mean, I can give you an analogous situation. There's a case called Matter of Chapis. It's a court of appeals case.
We can hear you.
Hold on.
We wouldn't want to miss a word.
I don't know what I'm saying until I get here. There's a case called Matter of Chapis. I can give you the site. It's a court of appeals case. It involves the liquor authority, and it's not directly involved, but what happened there was a special prosecutor told the licensee that if you cooperate with us, you will not lose your license. And he did. And then the liquor authority promptly canceled his license. So the Court of Appeals said, no, he has a right to rely on comments made by a prosecutor, and in reliance, they wouldn't lose license. So yes, and I probably give you a lot more cases if I have the time, where if there is a reliance on the word of an agency that you can go forward with.
Even when it says don't rely on it.
Yeah, but
even when it says don't rely on it.
The difference between that case and this one is in that case they said rely on me, and our declaratory rulings say don't rely on me.
They say it's limited to the facts. I don't think it says don't rely. It says it's limited to the facts.
Right, they're limited to the facts. It's binding on the authority on those facts.
And this
as
is
Mr. Cosmo indicated, they can't be undone retroactively.
And I would like to say, with regard to that, and then I'm finished, is just to give you an idea, you have the Yankee Stadium rule, right? And there have been a number of stadiums after that look at the Yankee Stadium ruling and copy the facts. That's exactly what they do. They say, the Liquor Authority said if you set up this kind of company, and this kind of company has this kind of relationship with the stadium and doesn't have these relationships with the stadium, that you can have this and you don't have a tight house problem. And exactly what happens is they take the facts and they copy them.
But then it's all disclosed to us.
It is generally speaking.
Well, what we're talking about is not ever.
I'm not arguing with you that.
No, but I mean, that's a big difference.
I'm only suggesting.
I mean, so the other alternative that has been batted around is perhaps, and it's been batted around since Ms. Flug was here, is perhaps get a third-party permit that not only gives us the information but then gives us jurisdiction.
Well,
which I don't think anybody wants.
I'm sorry, I put that forward. So I think third-party permits.
I guarantee you they wouldn't want it.
Well, that's a different issue. Okay, but I think that third-party permits is a good idea personally, because I think then you get to have jurisdiction over the people. You have something to say, and then you know exactly what you're doing. But that's another step. Those are the points I wanted to make. Thank you very much.
Thank you. Thank you.
Mr. Bookman.
Just a few quick points based on what was just said. First, I think what we're talking about is if you're going to do a percentage, the percentage should be based on each sale. It's the only thing that's simple. It's the only thing that's enforceable. Liquor Authority does not have the ability to look into what people's annual sales or profits are. If it's going to be a 10%, it's a 10% per transaction. Straightforward. Number two, food concessionaires are not all the same. I've gotten food concessionaires for permits for people who are they're like food vendors in an establishment, and they're selling directly to the consumer. So obviously they're keeping 100%. They're not taking a percentage of the licensee's bar revenue or their revenue. They're selling. They're the food purveyor in a food hall. So I don't think it's analogous. Third, it's a very vibrant market. We are in the largest market in the world, perhaps. I'm not concerned that if any of the current companies can't figure out a way, to make a profit based on your advisory, there will be 100 others willing to come in and do it for less. And by doing this and creating a level marketplace, you will actually increase competition in the marketplace, which I think is a positive thing for the state of New York to encourage. And last, as far as
once again, that absolutely is not my goal or interest here. And as far as the third-party provider,
and that's the last thing what I wanted to say is that we're not talking about regulating third-party providers, delivery services, or anything else. We're talking about regulating the businesses that you license and what they're allowed to do. And they're not parties to any of these advisories that 6 or 7 companies over the last 11 years, chose to come to you. So there's nothing retroactive here. It's prospective. It's telling businesses what they are allowed to enter into and what you would consider in violation of their liquor license. So you could do pretty much whatever you want here, whether it's your proposed 10%, whether it's less per transaction, whether it's less, or whether you say, you know what, there are too many individual problems here, so we're just going to stick with the law, and it's 0%.
Thank you.
All right.
Is the law 10% or less than 10%? Is the landlord exclusion now? Is it 10% or is it 10% or less?
And we have gone beyond that.
It's not in the law.
It's not a law, though.
I understand.
All right, we have, besides, hold on.
Well, just let her come up.
We have 2 people. I'm just going to call them in the order.
Okay.
All right. Is there anybody else besides Mr. Tomaszewski and Ms. Flug who want to speak? Sorry, it's Mr. Skeen. Okay. So, Mr. Skeen, you were first to come on. Come on up.
Very briefly, I would just like to comment on the third-party permit. Mr. Chairman said that no one would want that. In my submission, I've alluded to that.
You did, but we're not considering that today. I get it. And to defend Ms. Flug, who I dropped into this, that was 4 years ago. Where she stands on third-party permits now, I have absolutely no idea. I'm going to guess she's against it.
My clients' clients would be happy to qualify for that.
But Ms. Flug is a good attorney, and I'm sure she has evolved since she left here.
All right, Ms. Flug.
Not at all.
My hand wasn't up about the third-party permit issue, but so far today you've had Mr. Kozlow, Mr. Danow, Mr. Mallon, Mr. Bernstein all talking to you about declaratory rulings. And I think the reason that they're talking about that is, I believe it's the last paragraph of this advisory has this line in it that says any past declaratory ruling that disagrees or isn't in line with this advisory can no longer be relied on or is retracted. I don't have the language in front of me. And I think that's where this ambiguity comes from. And if the board has a specific ruling that they're talking about, I think it would help everybody and give guidance if they just said what that is.
But what's more clear than you can either have specific rulings or I think it's very clear when it says all of them.
But
None of them should rely on it. I mean, that's essentially what all means.
If you're taking the past body of history that you've developed through the declaratory rulings and trying to codify it in this,
We're not.
lack of a better word,
We're not.
you're not.
We reviewed them all, of course, but this is not an attempt to codify every declaratory ruling.
But if you see that there are some that contradict with your current position in the advisory, why not just say whose those are? Why make the industry guess?
Oh, we could
which
look
one
at
does
that,
the
but
board
there could be
think?
hundreds that contradict. I guess we could take a look at that.
Because then the risk is on the industry to say, well, I don't know, Commissioner Ford and Commissioner Fan might not think that this one contradicts, but Chairman Bradley thinks it does.
But the other option is, and I don't know how many people would be affected by this, but they can always ask for another declaratory ruling to see if it does conflict. If they're talking about this advisory and it's become so fact specific that they think they apply to a declaratory ruling that this advisory, based as it is now, says does not apply anymore, then they can ask for another one.
I think for the point of clarity, which is what the advisory is supposed to be, it would be more beneficial and not have all these people asking these questions if you just said, you know what, that advisory in 2018 we think is no longer valid because it contradicts this, rather than have this whole process of us guessing. Because if
But
you already know,
you're aware that many of these advisories deal with multiple issues, not just this issue. I mean, meaning that this issue could be one of 3 or 4 issues on an advisory. And I don't know that would make sense to knock out a complete advisory.
well, you wouldn't have to knock out the complete advisory in your, ruling. You would say in your advisory and this portion of that ruling, because otherwise you're really asking everybody to guess what you're thinking and what your interpretation is. When you obviously put it in because you have a clear belief that some of these declaratory rulings are no longer good.
Yes.
So rather than have the industry play a guessing game, ask more questions, why not just tell the industry?
All right, we'll talk about that. Thank you. And I'm sorry to drop you in the middle on that.
Anyone else? I can't see over. All right. So those are our speakers, Chairman.
Thank you. This is not going to be voted on today. I don't know if anybody thought it was, unless somebody next to me is dying to do this right now. We're going to go back and talk about it, and thank you for being brief and concise. And I'm going to go read everything again, and that's it.
At some point,
yes.
When you come up with it, can we get another shot at what you come up with, or whatever it is?
I don't know that we'll get another shot. I'll talk to them. I don't know what the procedure is.
Well,
Traditionally, whatever the procedure is, we're going to go through that.
just so everybody knows going forward, at some point, the relevant staff will put together, based on what happened today, perhaps changes to the current draft, speak to the members separately because they can't discuss it together, and then at some points we'll go back on the calendar, a new proposal for the members to consider, and then at that point the chairman will decide whether or not to take additional comment or vote on the proposal.
Yeah, I'll take that under advice. I know what your all answer is. So. I don't need to hear from you. I know exactly what your answer is.
With that, this meeting is adjourned.